Are there unique sick leave laws in collective bargaining? Imagine negotiating your work benefits and finding that sick leave terms are different from what the law states. Can your union make those changes? Let's find out. In many cases, collective bargaining agreements can include specific sick leave rules that differ from state or local laws. But these agreements must still follow certain rules. They can set benefits that are better than the law requires, but not worse. For example, some states like New York allow unions to negotiate sick leave provisions that are different from the statutory minimum. These agreements can specify how many days employees can take or how sick leave is accrued, as long as the benefits are comparable or more generous. The agreement must mention the relevant law and clearly state that the benefits meet or exceed legal standards. However, laws set minimum standards that cannot be lowered by a union contract. For instance, California's paid sick leave law guarantees a certain amount of leave per year. No matter what a union agreement says, employers cannot provide less than that minimum. If a collective bargaining agreement tries to do so, it is considered invalid. In some states like Illinois, laws explicitly say that union agreements must meet or surpass the legal sick leave rights. This means the contract cannot reduce employee protections below what the law guarantees. The law acts as a baseline, and unions can negotiate for more, but not less. Both law and union agreements often cover how sick leave can be used, whether for personal illness or caring for family members. They also address how leave is accrued, how employees restore leave after leaving the job, and protections against retaliation. For example, Washington state law allows employees to use sick leave or other paid time off to care for family members, and union contracts can specify additional rules as long as they respect the core legal protections. Employers and unions should clearly reference applicable sick leave laws in their agreements. They need to ensure that the negotiated benefits do not conflict with legal requirements. Employers must keep track of sick leave accruals and usage carefully, following both the law and the union contract. Anti-retaliation protections are usually protected by law regardless of the collective bargaining agreement, so employees can exercise their sick leave rights without fear of punishment. In summary, unions can negotiate unique sick leave provisions, but these must always meet or exceed legal minimums. Laws set the floor and collective bargaining agreements can raise the bar but cannot lower it. Clear references to legal standards in the contract help prevent disputes and ensure employee rights are protected.